Hello, everyone, and welcome to this seminar, which is part of the Litigating Abuse of Dominance Cases mini-series. We're now at session 4, and this is going to deal with interim injunctions in abuse of dominance cases and is considering particularly strategy and tips. Well, just because we've had Brexit, it doesn't mean that competition law in the English courts and tribunals has come to a full stop. Far from it. And so what do you do if you're a claimant and you think or believe that another entity is abusing its dominance and you feel that there has to be some interim relief? What do you need to do to get an interim injunction? Perhaps to hold the ring, and perhaps equally importantly, what you do in order to try and resist such an attempt. Well, these are the topics that our speakers today are going to have a look at, taking really quite a strategic view of what is needed in each case. That is to say, from the claimant's perspective, and looking also at the documents that you need, and from the defendant's perspective. So we're going to start off with the claimant's perspective, and Aaron Khan is going to talk on that. His practice focuses mostly on competition law. It involves a range of cases across the whole spectrum of competition law issues. So this includes follow-on and standalone damages actions, collective proceedings, and regulatory investigations before the Competition and Markets Authority and the European Commission. So, Aaron, over to you.
Thank you, Sir Richard. So I'm intending to cover two main topics in my section of this seminar. The first is to set the scene by recalling the test that a claimant must meet when seeking an interim injunction, and also covering a couple of practical issues, such as where and when an injunction application should be made. And then secondly, I will run through a series of practical tips from the claimant's perspective that I would suggest should be borne in mind when seeking an interim application. So turning to the next of my slides, the starting point then really is the legal tests which the claimant must keep in mind when seeking an interim injunction. And these are likely to be familiar to many of you as the long-standing American cyanamid principles, but a brief recap may still be helpful. Broadly speaking, the court takes the overall question of whether to grant an interim injunction in 3 stages. So first, it considers the threshold question of whether the claimant's claim raises a serious issue to be tried. Second, if there is such an issue, then the court will consider whether damages are an adequate remedy to the parties if an injunction were granted or refused respectively. And then third, if there is any doubt as to whether damages would be an adequate remedy, the court will then move on to consider the balance of convenience. It's worthwhile expanding on each of those steps in a little more detail. As to the threshold for a serious issue to be tried, the criterion is not a high one, as you will see from the brief extract from American cyanamid that I've set out on this slide. Generally speaking, the court should avoid resolving conflicts of evidence as to the facts and should avoid seeking to need to decide difficult questions of law. But it has been recognised on a few occasions that claims involving competition law, and especially abuse of dominance, will involve complex issues of fact and evidence that would, in turn, raise serious issues to be tried. For example, in the network multimedia case, Lord Justice Mummery said that in general, the abuse of a dominant position is a complex question, both of mixed facts and law, which should be determined at trial on the basis of tested and documentary evidence and rival submissions. However, one of my practical points that I'll come to mention later on is that I would sound a note of caution against assuming that the serious issue to be tried threshold will be easily satisfied. There have been a few, especially recent abuse of dominance cases, where the courts have been astute to scrutinise the cases and to ensure that they are reasonably arguable, which is why I think it is important to make sure that the basis of the claim is set out as clearly as possible. But assuming then that the court considers the claimant has raised a serious issue to be tried, then the next question is whether damages would be an adequate remedy for each party. And so there are two considerations here. The starting point is whether, if the applicant were to succeed at trial, it would be adequately compensated by way of damages, and would the respondent be in a financial position to pay those damages if it transpires that it did indeed have a valid claim and an injunction was wrongly refused. And then the second is that if damages were not an adequate remedy for the applicant, then the court will go on to consider whether damages would in fact be an adequate remedy for the respondent if it transpires that an injunction was wrongly granted. And then in the final question, the court will take the approach that if there is doubt as to whether damages would be an adequate remedy, it will then consider the balance of convenience, which in essence is a more general balancing exercise of the competing considerations both for and against granting or refusing an injunction. And there's no general list of factors that should be taken into account, but one that often comes up is a concern to, where possible, preserve the status quo, which is essentially the state of affairs proceeding before the commencement of proceedings, or where the period before commencement of proceedings is very short. It will be the sort of state of affairs before the last major change. So what I've outlined so far really are the steps involved in considering an application for an interim prohibitory injunction. But if we now turn on to the next slide, we'll see the position in relation to mandatory interim injunctions. Now, in this respect, as you'll see from this slide, generally speaking, the considerations are quite similar, where an applicant seeks either a mandatory or a prohibitory injunction. However, it's often the case that the courts will be slower to grant mandatory injunctions because they are more intrusive in their nature. In essence, they will require the injuncted party to actively take certain positive steps. And the particular concern there is that that may well carry a greater risk of irremediable prejudice if the injunction turns out to have been wrongly granted. And in particular, what has often been seen is that where a mandatory injunction is sought, the courts may require or may seek to find a higher degree of assurance that the underlying claims upon which the application for an injunction is based are well-founded. However, it's not an invariable practice, and the authoritative authority states that courts will be particularly likely to require a higher degree of assurance, where the grant of an interim injunction will cause irremediable prejudice to the defendant. So that gives a broad overview of the tests that a claimant must meet when seeking an interim injunction. The other point to note really here is that when one stands back from the detail, the overall approach that the court is seeking to take when considering whether it should grant or refuse an interim injunction is to ask itself which course of action seems likely to cause the least amount of irremediable prejudice to one party or another if the decision to grant or refuse an injunction proves to be wrong. So that covers the legal test that a claimant must satisfy in seeking an interim injunction. And if we turn over to the next slide, I now pick up on another practical issue, which really is the question of where an interim injunction should be brought. Typically speaking, there are two broad routes available to a prospective applicant for an injunction. In competition cases, you either have the High Court or the Competition Appeal Tribunal. In respect of the High Court, the reason you have to go to the High Court rather than, say, to the County Court for interim injunction is that competition claims must in general, or in fact must be, issued before the High Court, and specifically either the Chancery Division or the Commercial Court as appropriate. It's also worth keeping in mind that the Competition Appeal Tribunal is also a route available for interim relief. So the tribunal has power to award interim relief pursuant to the Competition Act, and helpfully the statute provides that when deciding whether to grant an interim injunction, or indeed any type of injunction, the tribunal must apply the same principles as the High Court. One particular factor that is likely to influence the decision as to whether an injunction is sought before either the High Court or the Competition Appeal Tribunal is the nature of the arguments that will be run in the underlying claim. If the claim is to be made up, as was the case in the Preventex and Royal Mail case, of both competition and non-competition claims, in this case it was a mixture of competition and breach of contract, estoppel-based claims, then the High Court will be the appropriate place to bring proceedings so that both sets of claims can be run together. The other practical question to consider when seeking an interim injunction is addressed on the next slide, which is the question of when an application for an interim injunction should be made. The basic principle is that an order may be made at any time, including pre-action if necessary. And in theory, it is possible to make an application for an interim injunction on or without notice, i.e. an ex parte basis. But having regard to the circumstances in which ex parte applications for interim injunctions are normally made, it's very unlikely that a competition case would fall within any of the, say, urgency type considerations that would require no notice to be provided or would permit no notice to be provided. Normally, 3 clear days notice is required for any application for an interim injunction. But the key point really here is don't delay once it's clear that an interim injunction is to be pursued, because one of the factors that may well run against any prospective claimant is that any delay may undermine the suggestion that an interim injunction is necessary. So that deals, I think, with the scene setting in respect of seeking an interim injunction and the practical questions inherent in that. The next 2 slides, if we turn over to the first of those, set out a series of practical tips that I would suggest should be borne in mind when seeking an interim injunction. Now, generally, as David will go on to mention in his section, it's important to evidence how each of the conditions are satisfied as fully as possible. And one point I wanted to add in relation to that at an early stage is that if an injunction is to be sought before proceedings are issued, it is still extremely important to provide the basis of the claim as fully as possible. And I suggest that it's strongly preferable to provide draft particulars of claim, even if they are in draft form, as part of the application documents. That's beneficial because it shows confidence in the claims, it shows the credibility of the proceedings that are to be brought. And of course, it is possible, if necessary, to caveat that these are draft particulars of claim that are subject to amendment, but it ensures that the basis of the claims are evidenced as fully as possible. And I suggest that's particularly important, bearing in mind one of the comments I made at the outset, which is that courts, whilst aware of the fact that the threshold for serious issue to be tried is a relatively low one, are still astute to scrutinise claims in order to ascertain whether they are seriously arguable. And some claims have been refused an interim injunction on that basis. My second main tip is to consider the reasons why an interim injunction is necessary. And one particular question that can often crop up is, why wouldn't an expedited trial be sufficient? So why wouldn't speedy directions to trial be more appropriate than the potential prejudice that could be involved in an interim injunction? So it's important to be very clear at the outset why this is necessary relative to bringing proceedings on much more quickly. And then my other tips are also set out on the final of my slides. If we can turn to that. When you are preparing correspondence, and particularly if you think that an interim injunction is in the offing, it's important to keep in mind that these will ultimately find their way, or could well find their way, before the court. And one of the key points to keep in mind here is to keep a consistent position as much as is possible, so that one of the issues that does not become live at the hearing is that the basis of the claims, or the basis upon which an injunction is sought, has shifted somewhat. The second of the suggestions on this slide is to think very carefully about the relief that is sought on an interim injunction. You'll note from my summary of the legal principles that generally courts are more cautious when a mandatory injunction is sought. They will prefer much more to hold the ring, to preserve the status quo, which is much more feasible by way of an interim injunction that's prohibitory in nature, whereas a mandatory injunction may involve imposing new terms or relationships, and courts are generally more cautious in doing so. And in framing the relief, do so in a way that's realistic and workable. The courts will want to be clear that what they are seeking to order will in fact be practicable. And then my final suggestion here, as you'll see, is to consider, particularly in the current legal landscape, whether it will also be necessary to apply to serve both the application and the claims out of the jurisdiction. And a recent judgment that's well worth taking a look at in this example is the Competition Appeals Tribunal's judgment in Epic Games and Google Apple, which is a case where the president heard an application to serve a claim for an injunction. This wasn't an interim injunction, but a final injunction out of the jurisdiction, and contains an extremely useful summary and discussion of the relevant principles that the tribunal will take into account. So that's an overview of the principles and of a series of practical tips that I suggest need to be borne in mind from the claimant's perspective. And so I think, Sir Richard, it's back over to you.
Thank you very much indeed, Aaron. For those who are listening or watching, please do put some questions down for the participants to consider. It's very much the object of these webinars to have discussions, as well as you being given some practical tips and so on and so forth, because issues arise, and particular issues may arise which are worrying those who are listening, and the idea is to have a discussion if we can. So you put them down, and then I can put them to the panelists. Now, next we're going to move on to the consideration of what documents you will need for any interim application for an injunction. And David Heaton is going to deal with this. David is a former solicitor and a management consultant in Australia. He was also an associate of Justice Heaton in the High Court of Australia, Australia's highest court, of course. He was called to the English bar in 2015, and his practice comprises competition law and commercial law and public law cases. So, David, over to you.
Thank you very much, Sir Richard. As Sir Richard has mentioned, I'll be covering the documents and materials that you need when you're looking to bring a claim, or an application rather, for an interim injunction in an abuse of dominance case. I'll look first in overview at the legal documents and then discuss the kinds of evidence and other documents that you might use to substantiate your claim that each of the requirements for an interim injunction is met. My recent experience in this regard includes the PreventX case that Aaron mentioned, and I'll use that as an example in a few of the instances that I give below. We'll move to the next slide. The basic legal documents that you'll need for an interim injunction, as indeed any application, are an application notice, the supporting evidence, the draft order, and as Aaron has said, ideally, draft particulars of claim. And I would simply endorse Aaron's comment that while not essential, they are highly advisable for two reasons in addition to those he gives. First of all, putting the particulars in the form of particulars avoids an overly long witness statement that has buried in it the details of the claim. But secondly, one doesn't want to be drafting particulars of claim in a hurry, in particular, having nailed one's colours to the mast to some extent by bringing an application, but without having fully drafted out the claim and thought it through entirely. So those are two further reasons why, because of the inherent complexity of an abuse of dominance case, draft particulars are certainly worth having. And indeed, in my experience, the courts show some flexibility about minor amendments being required to those, sometimes in light of points raised in opposition to an application. The key points to consider that arise on these documents in general terms are, first of all, the framing of the order. Aaron has rightly said that whether you need an interim injunction is a strategic decision that you need to make carefully, having regard to all of the circumstances. And in framing the draft order, you will have to think very carefully about what exactly your client is trying to achieve by its interim relief. The simplest and easiest kind of case is where an alleged dominant party is sought to be required to continue to do what they have been doing, usually to deal with your client, to keep something that they've been doing, keep doing something they have been doing ideally for a long time. But where the court is asked to prevent something that has not yet started or has only just started, that again is something that ought to be capable of being dealt with in an order in relatively simple terms. Where you are trying to require something to do something they've not previously done in particular, framing an order can be quite challenging and really does need very careful thought from the outset. Aaron touched on the distinction between prohibitory and mandatory injunctions. And while that distinction is typically made between positively requiring something to do something, a mandatory order which is said to be harder to get, and prohibiting them from doing something which is perhaps easier. In this context, as Aaron rightly said, one is looking in general more at what has been done up to the point of grant of the injunction. And so while it is true that, for example, an injunction requiring a party to continue to supply might be classed as mandatory in a strictly analytical sense because it is requiring somebody to do something positively, it's not merely restraining them. In practice, that kind of injunction will probably be treated more like a prohibitory injunction for the purposes of the principles about the strength of the case that you require. Again, as Aaron has said, it is critical to ask at the outset, does the client really need interim relief? And in particular, the strategic choice that you might face is whether the client may be better off simply seeking an expedited trial. And that might depend in particular on what your client's end goal is. Do they want to go to a trial and win it? And do they need to do that really for them to succeed in this claim? Or, as certainly in some cases I've been involved in, is interim relief really being used by a claimant as a springboard for what is in truth a contractual negotiation? And might the claim not actually go to trial at all, things going well, and some form of relief being obtained early on? We go to the next slide, please, Paul. There are inevitably three key areas that your evidence will need to address. Those are the issues of dominance, abuse, and those two, of course, go together to establishing what is the serious issue to be tried. And then evidence that addresses the criteria relevant to the grant of an interim injunction. That's irremediable prejudice to both sides, the balance of convenience, and the ability to satisfy the undertaking and damages. We move to the next slide, please. The rule of thumb for dominance per Commission guidance is that a 40% market share will generally just about get you there. And of course, dominance can exist below that market share depending on particular circumstances. But that leads one to sort of approach things in a somewhat strategic manner by saying, if you are able to define a market where your defendant has a market share of 40% or above, and that is a credible market, that will certainly advance you a significant way down the road of establishing a serious issue to be tried in relation to dominance. There are also cases where dominance is relatively obvious. So in Preventex, for example, the defendant was Royal Mail, a former state monopolist, and it's very clear that nobody else has a nationwide network of pillar boxes into which products can be posted. You're not going to need a great deal here in terms of your evidence to establish dominance. And materials that you might be able to rely on are, for example, Ofcom CMA reports, other public decisions or regulatory findings. The key strategic question, particularly in a case where dominance is less clear-cut, is whether to put in what you might call a quick and dirty experts report that deals with the issues of market definition and dominance. Now, on the one hand, a report from a reputable firm of competition economists that is itself credible is likely to go a long way towards establishing that dominance is a serious issue for trial. The obvious disadvantages, though, are that it requires you to nail your colours to the mast on market definition very early on, and it might illustrate to your opponent ways that they can argue that that market definition is not a credible one, and the correct market is one in which they don't have the dominant position. You'll see too from the quote on the slide that it's certainly not as simple as following up with the report. In that Packet Media case, there were a bevy of consistent Ofcom reports, that all of which were to the effect that O2 and other mobile network operators in its position didn't have a dominant position on the relevant market. The claimant obtained a temporary injunction and then produced an economist's report to try and overcome those consistent findings by Ofcom. And you can see that from the judge's comment, the report itself was obviously not of high quality. The expert hadn't reviewed the documents, he hadn't been shown the defence, he hadn't seen the evidence before the original trial judge, and his conclusion wasn't actually that there was a dominant position, it was just that you couldn't soundly dismiss that suggestion. The judge, fairly, if his description of it is correct, described it as being of no value to me at all. So while it is a difficult strategic decision, what is obviously critical if one is putting in an expert report, that it does contain the relevant analysis and is a credible document. Next slide, please. Moving then to evidence of abuse. And this is to establish there is a serious issue to be tried, that the defendant has abused its dominant position on the market. That evidence will, in broad terms, need to address three key issues. The first is the nature of the claimant's business. The second is the defendant's role in relation to that business. So is it a supplier of a key input or service, for example? And the third is, of course, what is it? What is the defendant's conduct that is said to constitute the abuse? What has the defendant done? How does this affect the claimant? And how does this affect competition on the relevant market? In particular, where one is alleging what might be thought to be a novel form of abuse, it's certainly worth describing the conduct in question in some detail. It's also worth giving thought to where does that evidence best come from. Obviously, courts will, of course, pay regard to evidence from the claimant, from an appropriate person in the claimant with knowledge of the matters in issue. But if there is time, it's worth thinking about, are there ways you can bolster your case, either by looking to external parties who might be able to provide similar evidence that might perhaps seem more objective or more credible to the court and perhaps less self-serving. And again, that was something we were able to do in the Preventex case. The issue there was Royal Mail had refused to continue to provide a free post service for the return of sexually transmitted infection testing kits that contained patient samples. It wanted Preventex to use a tracked service, which would require the word tracked to have appeared on the return post package. Preventex was concerned that for customers using STI test kits, and particularly vulnerable customers, they might be concerned, first of all, that products would have to be returned over the post office desk, which is the case with most tracked products. And also, simply by the fact of the word tracked appearing on the packaging, that might discourage use and compromise what was perceived to be the anonymity and privacy value of the product. Now, it wasn't ultimately possible to get evidence from an end user to substantiate that, but it was possible to obtain evidence from public health officials in the local authorities that used Preventex's product about the importance to end users of confidentiality and anonymity in using the service, and the possible detrimental effect on that using the word tracked and making it a tracked service might have on the product and therefore on the market for STI self-test kits. As I've said, it's necessary to describe the claimant's business, but the judge will pick this up quickly, and it's advisable to avoid the temptation to oversell the business or the product. Evidence should also tend to leave the competition analysis to submissions. It's much easier and more helpful for everyone if the evidence is the actual evidence, and the submissions are then put by counsel in the appropriate document, the skeleton argument. Wherever possible, as is almost always the case when one prepares any kind of evidence, if there are contemporaneous documents that bear out a case, they should be deployed. And I'd encourage you to think creatively as to how that might be, how sort of contemporaneous documents, if you like, in a very broad sense, might be able to substantiate a case. So, for example, where a concern is reputational effect or detriment, or a degradation in service to end users, think about whether there might be, for example, complaints to a manufacturer client, customers where similar things have happened before, or perhaps even social media or customer survey data. It doesn't necessarily have to be a contemporaneous document in the sense of an email or a note of a meeting, the way you usually think about those documents. But again, things external to the claimant that lend objectivity to what they are saying are useful from that perspective. Could we go to the next slide, please, Paul? And then, of course, it's necessary to address the criteria for an interim injunction, which Aaron has gone through and which I won't repeat. From the claimant's perspective, the critical thing to address is what is said to be the irremediable harm that they will suffer, and in turn, why damages would not be adequate compensation for them if an interim injunction is not granted. And for the defendant, the converse. So if they have evidence to give on the topic rather than submissions, why it is that the claimant's loss, or that the claimant can be adequately compensated by damages. And also, if the defendant is running such a case, why the harm to them from an injunction is irremediable. And the kinds of things that have been accepted or might be treated as irremediable prejudice include things like permanent or possibly permanent damage to competitive structures and markets, loss of customers, reputational harm. Ultimately, too, these are all things that in certain circumstances courts will have to quantify in damages. But there is a degree of flexibility and also degree as to how extreme these harms might be that might then lead a court to treat them as potentially irremediable and justify granting an interim injunction in circumstances. The other point that both sides should cover in their evidence is that relevant to the balance of convenience. So that is to say, what are, from each side's perspective, all of the burdens and detriments of the grant in the case of the defendant and of not granting the injunction in the case of the claimant. So what other harm or detriments will they suffer, even if not irremediable, that is relevant to the balance of convenience, and you should ensure that your client addresses it thoroughly. Next slide, please, Paul. So the undertaking in damages is really a footnote to this discussion, but important to mention. It's an undertaking to compensate the defendant against whom an injunction is granted if it turns out that it was wrongly granted, i.e. if the claim ultimately fails or is withdrawn. And it is almost inevitable that it will have to be given. It's the price of getting your injunction. It may be more or less difficult to work out what the consequences are of giving that undertaking in a certain case. So if you're simply, for example, trying to hold somebody to the current price they're offering, it's obvious that if an injunction is granted, then the damages that are suffered are going to be the difference between the price they would have charged and the price they are charging. If, however, you're doing something like preventing somebody from entering a market altogether, it might be much harder to work out what your client's ultimate liability might be. Where there is any doubt as to the claimant's ability to ultimately pay an award of damages, consideration should be given to fortifying the undertaking, and that fortification should be offered in evidence. Next slide, please, Paul. So I'd like to finish with 3 key takeaways, bringing what I've said together by way of brief summary. The first, a point Aaron also mentioned, is think carefully about whether an injunction is necessary and is also strategically sensible, and then in drafting your order, think about exactly what you need. The second point is prepare early. Consider carefully the framing of the claim, who will give evidence and in what form you might prove things, and consider early whether economic evidence is required. And finally, direct evidence to key points, substantiate with documents where possible, and be creative with sources, in particular, in proving irreparable harm. Thank you very much, and back to you, Sir Richard.
Thank you very much indeed, David. Now we move on to the last presentation, which is going to be given by Fergus Randolph QC. And this will be looking at matters from the defendant's perspective. Fergus's practice covers all aspects of both UK and EU competition law, including, of course, abuse of dominance cases. He's presently involved in follow-on damages claims against Google and representing the Department of Health in an excessive pricing case. He's called to both the English and the Brussels bar, and so this enables him both to plead and to appear before the EU courts in Luxembourg. Fergus.
Richard, thank you very much indeed. I'm going to take this at a little bit of a canter so that we've got some time for questions. Can I have the first slide, please, Paul? Overview. Take every reasonable point, but take every reasonable point reasonably. A judge won't be impressed by kitchen sink defences. The second point is to take every reasonable point in a targeted and focused manner. Injunction proceedings are, by definition, taken at speed. Judges are busy and they don't want to wade through lengthy documentation and argument. In abuse cases, as we've heard from the previous speakers, the defendant is nearly always painted as the bad guy. Allegedly, that comes with the territory of being dominant. Try and paint a different picture. Judges are human and often will, at least initially, be tempted to take David's side in the Goliath battle, but focus instead, I would suggest, on the benefits of the defendant's business. Its activities, its model, and its benefits to consumers. Apple has recently deployed that very line of argument in response to the European Commission's decision at the beginning of this week to take forward an abuse case relating to the manner in which Apple app stores operate. And a good example of that line working in this jurisdiction was in the Street Map and Google case, where the High Court found obiter that Google's display of its own map and search results without including rival maps, which on its face might be thought to be problematic, actually improved quality and was objectively justified. Be careful what your client says. I only put this in because I was involved in the Aberdeen Journal's case a very long time ago, which was held in Edinburgh. It was the CAT. And the key document that we found was something from the dominant defendant in which the interesting instruction was set out as follows: keep your foot on their neck. Now, that's not the type of thing you want when an injunction is being sought if you're a defendant. So try and ensure that nothing is said that can boomerang back. Defendants should also keep in mind the possibility of mid-course undertakings, suitable undertakings, which are short of the relief sought, but are sufficient to protect the applicant's interests until trial and do not wreck the defendant's modus operandi. That's particularly relevant in alleged abuse of dominance cases, where the claimant may be seeking injunctive relief which would or could radically and detrimentally alter the defendant's ability to continue to practice its trade. Never forget, it's not unlawful for a defendant to hold a dominant position. It's not unlawful for that dominant company to be successful and prosper. As Mr. Justice Roth put it in Preventex, competition law is not a general law of fair trading. Could I have the next slide, please? Now, Brexit impinges on the debate. I'll take this quite quickly. Pursuant to the 2018 European Union Withdrawal Act, as amended by the 2020 European Withdrawal Agreement Act, direct EU legislation, which includes Articles 101 and 102, continue to be part of English law unless and until repealed. Well, they have been. And that's pursuant to Regulation 62 of the 2019 Competition Amendment, etc., EU exit regulations. And that provides, Regulation 62, provides that any rights, powers, liabilities, etc., that are derived from, amongst others, Articles 101 and 102, cease to be recognized and available in domestic law, brackets, and to be enforced, allowed, and followed accordingly on the coming into force of these regulations. And they came into force at the end of last year. Accordingly, the competition law practice direction in the White Book has been amended to omit all references to 101 and 102, except in relation, and this is important, except in relation to EU or alleged EU competition infringements which occurred prior to 11 p.m. on the 31st of December 2020, and the position is mirrored for CAT proceedings by operation of Regulation 16 of the 2019 regulations. Now, how is that relevant to injunctive relief? Well, insofar as 102 infringements taking place after 11 p.m. on the 31st of December, any application for an injunction based on 102 will have to therefore be based on 102 as a foreign law, which needs to be proved by expert evidence and will be determined as a matter of fact by the court on the balance of probabilities. That will complicate matters, undoubtedly, for any applicant, and the defendants will undoubtedly refer to the well-worn words of Sir Terence Etherton in the Van Beckenstein case, in which he made clear that courts dealing with injunction applications should not get into difficult points of law. Now, it may well be suggested by defendants that this would be exactly one of those areas. Defendants will also wish to rely on Section 6 of the 2018 Withdrawal Act, which provides in material part that any court or tribunal is not bound by any principles laid down or decisions made on or after 11 p.m. on the 31st of December by the European Court, and 6.2, a court may have regard to anything done on or after that time by the European Court, another EU entity, aka the European Commission, so far as is relevant to any matter before the court, and 6.4a, the Supreme Court is not bound by any retained EU case law, and that jurisdiction of not being bound has been extended to the Court of Appeal, and there's been a recent judgment to that effect that Sir Richard may wish to discuss when I've finished my talk in about 5 minutes. So no longer bound can also go off on a what might be called a frolic in the light and on the basis of Section 60A of the Competition Act 1998, which provides in essence that the duty previously imposed on courts and tribunals to reach decisions consistent with the relevant legal principles laid down in the treaty, the TFEU, and the Luxembourg courts, no longer applies amongst inter alia, where there are differences between the markets in the UK and the EU, or where generally accepted principles of competition analysis dictate otherwise, or where particular circumstances permit such a divergence. That's very wide-ranging and pretty vague, and can undoubtedly be exploited by defendants, particularly when the first criterion of a serious issue to be tried has to be determined by the courts. And finally, there's the question of jurisdiction. This has been mentioned previously, in particular in relation to Epic Games and Apple and Google. Obviously, in the light of Brexit, the Brussels regulation recast no longer applies, and so we fall back on the common law, and it is undoubtedly, whatever one thinks of that, a more flexible instrument. And in Epic Games and Apple, it was deployed by the judge because it was an ex parte application, with the effect that permission to serve out on Apple was refused. Could I have the next slide, please? Now, in terms of the serious issue to be tried, the first criterion in any injunction application, I would suggest there are three things one really needs to concentrate on as a defendant: dominance, abuse, and causation. In many applications, the defendant accepts that for the purpose of the application, the court can deem it to be dominant. Well, as in the Preventex case, and as David said, it's going to be pretty unlikely that any argument to suggest that one's not dominant would actually succeed. However, I would suggest with respect that one needs to be very careful about conceding dominance for the purpose of the application, because it's one major hill for the applicant to climb, and one shouldn't leave that position without full thought. In terms of the abuse, this is a key battleground for the first criterion in terms of prima facie case, and will be where much of the debate takes place. A good example of a defendant resisting part of a claimant's case on abuse on an injunction application can be seen in the aforementioned Preventex case, where the court held that the well-established case law based on United Brands couldn't be circumvented on the basis that there was an abuse, because the price increase in question would lead to a limitation of the market. Issue of causation, that's often overlooked. Claimants will often assert that their business has been seriously damaged by the allegedly dominant defendant. But they may well not have been as successful as they might have wished, but that could be for a myriad of different reasons, all of which, or some of which, would be extraneous to the defendant. Time and resources, therefore, I would suggest, should be spent on investigating the claimant's position. Was its business ever viable? Did it ever make bad business decisions? Was someone else to blame? Final slide, please. Thank you. In terms of the balance of convenience, we've looked at this in the two previous speakers. I'm not going to mention much about this issue, apart from obviously defendants would rather go for the status quo ante than anything else. The prohibitory mandatory issue, again, we've seen what the position is on that. I would just mention that in the Preventex case, Mr. Justice Roth found that it didn't really matter whether the form of the injunction was mandatory or prohibitory. So take that as you will, but I would generally go with the view that's been expressed before me, which is essentially a mandatory injunction is going to be more complex to get than a prohibitory one. And the final slide. So there is scope, plenty of scope for defendants to protect their position, even if they are dominant. And that's a fortiori in a post-Brexit world. Don't forget to take every reasonable point reasonably. And finally, there's a very recent example of a 102 claim for injunctive relief in the form of a claim that was made public yesterday on the CAT's website, which was lodged on behalf of Newcastle Football Club in relation to the proposed takeover of the club by the Saudi Sovereign Wealth Fund, which was blocked by the Premier League, and allegations of illegality pursuant to 101 and 102, that blocking taking place before 11 p.m. on the 31st of December. Allegations of 101 and 102 breach are made, together with a request for injunctive relief. Thank you very much.
Thank you very much indeed, Fergus. Well, just in case anyone is interested in this little development of the law by the Court of Appeal, it's the tune-in case involving a dispute between Warner Brothers, effectively, and a US outfit called TuneIn, which allows its customers to tune in, literally, to thousands and thousands of various radio programs. And the action was to try and stop that from being done on the basis of a breach of copyright. And it succeeded both before the judge at first instance and in the Court of Appeal. And in the Court of Appeal, TuneIn's counsel argued that the court should depart from a very long series of CJEU decisions. I think Lord Justice Arnold collected together 25 of them on the area that was being discussed. And the court decided that it was not going to depart from them, although, as Fergus has said, under the regulation that was issued at the beginning of this year, pursuant to Section 6, I think it's Section 6(5)(a) of the Withdrawal Act as amended, the regulations can be made to enable not only the Supreme Court to depart from previous CJEU decisions, but also other courts. And the Lord Chancellor made a regulation permitting the Court of Appeal and the Inner House in Scotland so they could depart from them. But they have to use the same test as the Supreme Court would use in relation to domestic law cases. And that's the test, of course, that the Supreme Court has to use in relation to prior CJEU cases. So what did the Court of Appeal say? They said that the test really is a very high one. It's not simply that you might feel that it's wrong or that it would be decided in another way now, but also that it is impeding the development of the law, or that it would produce injustice, or that it would be contrary to public policy to follow the previous CJEU case. So it's a very high test. So that's just a little bit of an added extra for you all, which is not directly concerned with the matter in issue. But I have got a question for you from somebody who is listening in and joining in, and that is this. Assuming a competition-only case, unlike Preventex, is there any reason to go to the High Court rather than the CAT? Well, Aaron, you raised this issue first. Perhaps you'd like to deal with that question.
Thank you. I think it's a very good question. And immediately, there's not a particular reason that springs to mind, although other speakers may feel differently. One particular practical consideration that one may keep in mind is how quickly you may be able to get an injunction on in the respective locations. And that can be found out by way of making inquiries. But that would be one thing that I would be particularly keen to check, is if you think, particularly in a very urgent case, if you could get yourself on before either the tribunal or the High Court quickly, that would be a very strong factor for bringing the claim before that particular court. But over to any of my fellow panelists for the other perspectives.
Well, I would entirely endorse that. I've been involved in cases where there has been a choice, and we've actually gone for the Chancery Division / the Commercial Court, because it's not so much that the CAT's slow, but well, some might say that, but I'm not going to say that. I think it's fair to say they have fewer resources in terms of actual judges available at any one time. And if it's an injunction, it's going to be urgent. And try your luck. If time is of the essence, and it will normally be an injunction application, try your luck in the High Court. David, I don't know whether you
David.
One further point I do have on that question is, perhaps counterintuitively, if you are bringing a more novel claim, there may actually be some strategic advantage in going to the Commercial Court or the Chancery Division to try and avoid a competition specialist judge. And that is simply because somebody with lots of experience is perhaps more likely to really apply the magnifying glass to a claim, whereas a less experienced judge might perhaps be more willing to accept that certain points are arguable or not. But ultimately, that's very much a question of luck of the draw in any event. Of course, if you're in the Chancery Division, most of the same people, or many of the judges anyway, will sit on the CAT and will have a good deal of competition experience.
Well, presumably, though, once you've made your choice, you're stuck with it.
No, you can transfer.
Well, how likely is it that you're going to be allowed to transfer? And it's not just a free-for-all, free transfer system, surely.
I mean, I think for the purposes of the application, you will be stuck with where you've gone for that. And then the claim, can more or less, I mean, if there's agreement between the parties, I think transfer is inevitable if that were thought appropriate, at least to the cat.
And particularly where it's only a competition point claim. Obviously, where it's mixed, then there are other issues at stake, and there's been recent authority on whether you should or shouldn't transfer. But yeah, David's absolutely right. You're stuck for the application, but then you can move across. So you might think, oh, I'll go for the High Court first, nice and quick case hearing, and then move across the cat in due course.
Yeah. Well, can I ask a question that I've been thinking about whilst I've been listening to all your very clear presentations? And I'm looking at this from the point of view of the judge who might have to hear an application for an interim injunction. And bearing in mind the nature of the action we're concerned with here, which is an allegation of abuse of dominance, and the fact that it is likely to involve large issues of fact and perhaps expert evidence, how likely is it, do you think, or put it another way, how easy do you think it is to persuade a judge that it's right to go now for an interim injunction rather than attempt to get a speedy trial on? Because from the point of view of the judge, it would seem to me that you'd be very much tempted, given the complexities, to say, right, I think we should actually go for a speedy trial because that's the more practical way to deal with this. Is that wrong?
No, but it depends on the facts, I would suggest, because if it's being alleged that the dominant undertaking is, to use Aberdeen Journal's words, keeping its foot on their neck, and that means that in the next week you're going to be out of business as a claimant, then a speedy trial is not going to really help. But Aaron, you raised this, so you may want to deal with it.
I think there's also a question of how speedy a speedy trial can be. So Richard's point's exactly right, in that if you do have very large swathes of factual and expert evidence, it's one thing to try and list a 2-week speedy trial. It's another thing to try and list a, say, 1 or 2 day speedy trial. Now, the CAT in particular has a fast-track procedure, which is designed to bring on smaller claims very quickly. And so I can see that where it's a relatively self-contained issue, where you can keep the evidence under control, that may be a much more viable alternative. Whereas if you have a much more substantial claim, which is going to require, say, 2 or 3 experts, and there's a series of factual witnesses, a speedy trial may simply be out of the question. And that may be something that needs to be factored into the evidence to explain why actually a speedy trial is just not workable on the facts of the dispute.
And which is why the mid-course undertakings that I suggested is often the way through, to cut through. So you've got this dilemma, you've got a problem, really urgent problem, but you've got matters of fact and law and expert evidence. Well, maybe the allegedly dominant defendant can offer something that's a halfway house that will keep the claimant in business, but won't actually injunct it from doing that which it says is lawful. And that, I don't know, Richard, would that soothe you as a judge?
Well,
would you be happy to?
I think as a judge you'd be very soothed by something like that, and then you could get on with the meat of it by making a timeline for as speedy a trial as you could. But there's another factor that I wonder how important this is going to be in the future, particularly in the context of interim relief. And that's the fact that now we are, as it were, back to domestic rules for service out. No longer, no Brussels 1 revised, looks as though no chance of joining Lugano anytime soon. So it's going to be our domestic rules, and therefore with the need to get permission to serve out in a majority of cases. And in the context of interim relief, how is that going to work? Because until you've got your leave to serve out and you actually served, you're effectively, if you're going to get any interim relief at all, going to have to do so ex parte, aren't you?
Yes. Well, that's what happened in Epic Games.
And
exactly what happened in Epic Games. And they didn't succeed in as far as Apple was concerned.
If you do that, then you've got the added obligation as a claimant to make sure that there is full and frank disclosure, not only in relation to your application to serve out, but also in relation to any other supporting evidence that you have in relation to your interim injunction application. Now, how much of a problem might that be, do you think? Now, David, you raised this question in the course of your slides about the need for service out in certain cases. But is this going to create a practical problem? And if so, are there ways around it?
Richard, I think it's obviously inherently undesirable for any claimant to have to be making an application on a full and frank basis, because you are, by definition, giving up points against you. Ultimately, though, it's not usually fatal to a claim, because you only come to court where you think you have a decent shot of surmounting those arguments. So I doubt that the need for full and frank disclosure will be, in and of itself, hugely problematic. What it will mean in a strategic sense, though, is that it's much harder to use interim relief as a springboard to sort of get you somewhere against a putatively dominant entity, and from there to work off for a settlement, just because the burden on you is much greater. The chances of having things set aside from material non-disclosure are much more real risk. I think it might make the whole undertaking look a lot more risky if that was your strategy.
Yeah, and in terms of the timeline, though, is it going to create difficulties or not? What do you think, Fergus or Aaron?
If you've got to serve via the Hague Convention, it certainly is.
Yeah,
well,
yeah, but all I'd say is go look back at what happened at Epic. I mean, I don't know how long that hearing was, but they put in a lot of evidence in support, and they failed spectacularly insofar as Apple. They were claiming against Google and Apple, and they lost in terms of service out was refused for Apple. So that was obviously pretty critical. Now, Aaron, I'm not sure what happened insofar as Google permission was given to serve out, not least because there was now a defendant in Ireland. But was injunctive relief given at that stage? I don't think it was. So that's another delay.
Well, the rule with Epic Games is that they're seeking a final injunction. I don't think at this stage they're pursuing interim. The most recent update I saw on the tribunal's website was that there's been an extension of time to file defences. But that's right, because there's going to be an inherent delay in the process if you have to go for service out. That makes it much more difficult.
And is there any way around this? I don't suppose there is there?
No. But 'twas ever thus in terms. I mean, Brussels recast doesn't impact on Apple or Google. I mean, they're headquartered in wherever, California, Seattle. It was, so that was always the case. And if you're looking at tech, a lot of them are headquartered outside of the EU, so no difference.
No, what I really meant was, is there any means by which one could try and, other than just saying I've got to do this ex parte, getting a court to grant the interim relief, or are the consequences of doing that going to be so great in terms of what the cross undertaking in damages would have to involve and fortifying that and so on and so forth, that it would be much more difficult for anyone trying to challenge what is alleged to be an abuse of dominance to get underway with all of this.
But are you suggesting that you would actually the court would grant the injunctive relief prior to determining the issue of service out? Or maybe at the same time?
Yeah, what I'm suggesting is that the court might say, right, ex parte, I'm satisfied you fulfilled the necessary conditions for service out, and therefore I'm going to treat this as giving you permission to serve out, and at the same time I will now therefore consider on an ex parte basis whether or not there should be an interim injunction. Now, is that feasible? I mean, in theory it is, but in practice I don't know whether that can be done.
I guess one particular factor the court is going to likely to want to be convinced about is the urgency issue. Because, I mean, if you go under the Hague Convention, it could be taking some time for service. There may be more or swifter forms of service. I can see a court saying, if you want me to grant this without the defendants being in the room, you'd better explain to me why this can't wait until they've been properly served and are required to turn up. And so I think that would put a greater burden onto claimants to show the urgency of the injunction sought. You would essentially need to be showing that you were in very serious difficulties in a very short space of time.
Yeah. Well, those are all issues that need careful thought, as well as all the other practical issues that the three of you have so clearly highlighted. And I'm sure there's going to be developments in this area of the law now as we move into a new landscape. Anyway, it's my great pleasure to thank the three of you for your presentations and your answers to those questions, and to thank those who have joined us for doing so today. Good afternoon to you all.